Mr. Rangel's statements over the last 10 minutes, and I listened to what he had to say very carefully, and let me say that it also troubles me that he is before the committee today without counsel. Are we going to consider his statement as a motion to continue this hearing?
Is that a motion to continue, Mr. Rangel?
I don't know whether first of all, my role here is as a respondent, and I am not here representing myself. I've been a lawyer long enough to know that it is very, very unwise for any person, a lawyer or a judge, to be his own lawyer at a proceeding like this. So I'm not in a position to make a motion unless we're talking about fairness, unless we're talking about someone contradicting everything I've said, unless any member has any question to ask of me.
Thank you.
And notwithstanding the fact that you're submitting your letter for the record, if there's anything I've said about that letter and all of the conversations we've had, I would think that notwithstanding procedure, Judge Butterfield, that fairness would allow you to say that this is a statement of how I feel as a person, as a member of Congress, and as the citizens that's begging for due process. You can call it a motion, and I can't quite frankly answer that question.
We appreciate that, Mr. Rangel. We will turn now to Committee Counsel, Mr. Chisholm, to introduce your team and to make your motion for the admission of evidence.
Madam Chair, Ranking Member McCall, members of the subcommittee, Representative Rangel. My name is Blake Chisholm. I am the Chief Counsel for the committee. To my right is Deborah Morris, counsel to the committee, and to my left is Donald Sherman, also counsel to the committee. At this time, Madam Chair, I would move to introduce Exhibits 1 through 549 into the record.
Is there objection?
Well, Madam Chair, if it pleases, with all due respect, I'm not in a position to pass judgment on what counsel is about to do. I've never known that this proceeding even existed as summary judgment, if that's what he's about to do. Any lawyer that I've talked with have said that this committee has no history at all.
If I may interrupt, Mr. Rangel,
Yes.
just to clarify this. There is, we were noticed, as were you, of this motion. I would like to make clear, however, that we will hear the motion, the argument from the committee counsel, and whatever argument you may choose to make, but that if you wish to be heard in an opening statement, if you wish to proceed with witnesses, we will hold any ruling on that motion in abeyance so that if you wish to be heard, we will hear you.
I appreciate the chair's statement. Would that include the right for me to have a lawyer?
You may hire whoever you wish as a lawyer. That is up to you.
Well, you've seen the record, $2 million already, and I've been advised that this hearing could cost me another $1 million. You've offered me the opportunity to have a legal defense fund, which would allow perhaps a lawyer to come into the case. If that's what you're saying, there is nothing I would not yield to for that purpose. But you know that if you're saying that we can't move forward, then that restricts me from getting a lawyer, not only financially, but the legal defense fund that you suggested I would have no meaning at all. If what you're saying, if there's anything I can do within the rules of the committee that would allow me to move forward with this,
Thank you,
not to object to just the procedure, but I did not know until a week ago that this 80-page would be the way you intended to judge my conduct. A week ago. So I can listen to what he is saying, but does this mean that he is going into this procedure, that I don't have counsel to guide me?
If I may, Mr. Rangel, if you could be seated. For clarification, the respondent has inquired of the committee whether a fund could be created where contributions could be made for legal representation, and has been advised by the committee that that is permissible. However, the retention of counsel is up to the respondent, whether you're to hire it at your own expense, through your campaign committee, or through a fund, is your decision, not the committee's decision.
All I'm asking, if I agree with you 100%, Madam Chair, all I'm asking for is the time to get counsel. I have lawyers from Washington, D.C. and New York are willing to give me free counsel to be able to come here because they don't think I've been treated fairly, and yet they say that if they do that, it's a gift and violates all of the laws. I heard that perhaps they can do it at reduced fees or fair fees. If only we had time to develop the committee. You tell me that I don't have time to do that. And so while you tell me that, yes, I can hire anybody, get anybody, not have a lawyer, you're also saying, and that's the third part of your letter, that time does not permit this matter to be concluded before the end of this session. And that's the nuts and bolts of what we're talking about. You tell me all of the things I could do, but you're not going to give me time to do it. I think no one can say that that's not the way this ends up. Yes, I can do these things, but you have to conclude this now and the next day. And my reputation, 50 years of public service, has to suffer because this committee has concluded that you must conclude this matter before this Congress ends. And all I'm asking for is time to get counsel. Time to get counsel. And you're saying now, I think, that you denied it before and you're denying it now.
I gather that you do not object to the admission of the evidence that has been proffered by committee counsel.
Well,
and therefore the admission.
I object to the proceeding, and I, with all due respect, since I don't have counsel to advise me, I'm going to have to excuse myself from these proceedings because I have no idea what this man has put together over 2 years that was given to me last week. And I just hope that the history of this committee, in terms of fairness, would be judged for what it is. So, with all due respect, and recognizing how awkward it is for the members of this committee, as colleagues and someone that would like to preserve the right of members to be judged by their peers with counsel, I respectfully remove myself from these.
Madam Chair, before the respondent leaves, may I ask the Chair an additional question?
Certainly.
Even though the respondent did not specifically make a motion to continue this hearing, I deem his comments to be a motion to continue. And I would like this committee to seriously consider a motion to continue. I would like for us to do it in executive session and discuss among ourselves what the respondent has said, because I take his contentions very seriously. I served as a judge in my state for 15 years, and I know the importance of counsel, especially in this environment. And so I'm going to ask that we deem his statements to be a motion to continue and that we discuss it in executive session.
All right, that is a request from one member to have a discussion on the, well, it'll be your motion to